I'm here sui juris in propria persona. I reserve all rights. I, Jonathan Troy Fayetteville Colin Schuster, comma beneficiary and sovereign, and here under fraud, menace, and duress. Fiduciary. This is a Social Security Certificate Trust action, which you are now a real party and interest to. I'm here sui juris in propria persona. I've challenged the jurisdiction of this court, and I don't understand. So I do need some questions answered. Is there a bond on this matter?
I believe you were PR. Actually, bail was set at $2,000.
There is a bond on this matter, correct?
Yes, there is.
Okay, and so is my social security number attached to these charges in any way?
I don't believe so.
You don't believe so?
I don't have any record of your social security number. So as far as I know, I don't know your social security number.
No, I'm saying is my social security number attached to these charges in any way?
Only in the extent that it's connected to your driving history.
So is that a yes or a no?
In some way, shape, or form, your social security number is in the system with records on you. That is true.
Okay, so you just told me there was a bond, which means this is commercial court.
It's not commercial.
Now you're saying that my social security number is attached to these charges. And so, which means this is a Sesticate trust action, which you are a real party and interest to. And I just told you I was the beneficiary. You're supposed to be charging the trust. You're not charging the beneficiary. And if you're creating bonds against my trust without my permission, I don't understand. Are you saying you're committing?
All right, guys, buckle up because this is where the chaos officially begins. The defendant immediately launches into sovereign citizen language, challenging jurisdiction and refusing to recognize the court's authority. The judge stays measured but firm, trying to ground the hearing in reality. You can feel the tension building as logic and fantasy collide, setting the tone for everything that follows.
I'm saying that you are subject to the jurisdiction of this court.
This matter cannot move until you've proven jurisdiction, and you failed to do so. And if you cannot prove jurisdiction, then this matter needs to be dismissed with prejudice because this is a commercial matter. I'm a non-U.S. citizen American national by way of American Samoa. I'm beneficiary. I am here sui juris in propria persona, and we cannot move any further on this matter until this is either dismissed with prejudice or you can prove jurisdiction.
So what would you like to do with your case? I assume, Mr. Parent, that you are not representing?
So the man cannot speak for me.
Okay, he's not speaking for you, but I am asking him a direct question, so I need you to let him answer.
Okay.
Yes, so the court did appoint us on this matter, but it sounds like he does not want my office to represent him, so I'm happy to withdraw.
You can dismiss yourself.
So would you like to represent yourself in the matter, Mr.
Please
Schuster?
do not tell me to shut up. You can dismiss yourself.
So he can't dismiss himself, only I can dismiss him. I'm asking you if you wish to have an attorney or if you wish to represent yourself.
This is a trust or Sesticate trust action. And so I'm here sui juris in propria persona. You know what that means. And so we can prove
Don't know what it means because it's nonsense, but nonetheless.
Prove jurisdiction, or we can dismiss this matter with prejudice.
So I'm not going to do that today. Here are your choices. You can have Mr. Parent represent you. You can choose to obtain private counsel, or you can represent yourself. Let's start there.
Now we see the court attempting to regain control. The judge forces a critical decision: lawyer or self-representation. Instead of answering directly, the defendant talks over everyone, rejects appointed counsel, and insists on his own made-up legal status. This moment matters because it shows the court giving fair options while the defendant actively sabotages himself. Clip
those three.
Nobody's going to represent me. I can present myself, as I said.
So you wish to go pro se? I don't need you to read the script. I need you to tell me if you wish to go pro se.
I told you I'm here sui juris in propria persona.
Ms. Roberts, are you there?
Yes, Judge.
Set this matter over and see if Mr. Schuster wants to give it another shot with his attorney or go pro se. It looks like this is the first pretrial. I suspect he's not prepared to set for trial today.
What is the first one? There's no plead.
Okay, I'm not speaking to you, so you're going to have to wait. I'm speaking to Ms. Roberts.
I mean,
Judge, I would ask that we set this matter over 1 week.
Do you want to come back to court in 1 week and try again?
we can finish this matter now.
We
There's no
can't.
need to
We
move
can't.
this any further because
So here's
it's
the
not
thing.
proven jurisdiction.
Here's the thing. It's not my position today to have to prove jurisdiction to you.
It is. It is your position because
It's
it is
not.
on the courts.
And I'm also not going to argue with you.
There's no
So
arguing.
I'm going to have you come back to court in 1 week.
There's nothing you can prove that you have jurisdiction. This man does not speak for me.
So we're going to come back to court on July
That
July
doesn't work.
1st.
That date doesn't work
Why doesn't it work for you?
because
Here, patience starts wearing thin. The judge explains procedure and schedules the case forward, but the defendant refuses to engage in the process at all. He keeps repeating jurisdiction challenges like a broken record. This clip shows the court clearly asserting authority while the defendant escalates, believing repetition will somehow force dismissal.
your end, and I have no more time for this matter. And unless you can prove jurisdiction, there's no need for this matter to move any further.
But you're going to come back on July 1st at 9 a.m. If you don't come back
That's
on
not
July
work.
1st,
Are you
then
threatening me now?
I'm telling you there's going to be a bench warrant issued if you don't
Are
show
you
up. So
threatening me now?
I'm giving you the choice of showing up
No,
or a
I'm
bench
giving
warrant
you the
issuing.
choice to vote for your actions.
We'll set this for July 1st.
Would you like to be responsible for your actions and set this further? Because you can do that, or you can dismiss this matter with prejudice.
I'm not going to do that today. So July 1st, 9 a.m., back in this courtroom.
You violated my rights enough.
We'll just hold Speedy for this
You
week, Ms.
violated my
Roberts.
rights enough. This matter needs to be dismissed with prejudice,
We'll see you back on July 1st,
or else what? You're going to threaten me?
or else the court will issue a bench
So
warrant.
you're threatening me now, Abigail.
I am telling you your
I'm telling
options.
you this matter needs to be dismissed with prejudice because antitrust action.
Signature here,
You're trying to
sir.
commit fraud.
Sir,
You're
Mr.
trying to
Schuster.
commit fraud. Miss, I'm
So-
speaking with Abigail.
You're done.
No,
you're done.
you can't tell me I'm done.
I
This
can.
is no, you don't have power to do that.
Your court case is over.
You don't have power to do that.
Sir, your hearing is over. If you don't take your paperwork and leave the courtroom, we'll have you remanded into.
This is where things turn explosive. The judge warns about consequences, including a bench warrant, and the defendant instantly reframes that as a threat. His tone sharpens, accusations fly, and control of the courtroom is openly challenged. It's a raw power struggle where the judge draws a hard line and refuses to be bullied.
We can address Jonathan Schuster, 480525748.
For the record, this man. is
Why
not-
don't you come up to council table, please, so we can create a record?
No, I don't want to give you any personal jurisdiction, so I'll stay right here.
No, you'll come to the council table if you would like to be heard and make a record. So you need to come up and turn on the microphone.
No, I don't need to do that for me to be heard.
To be heard, you need to come up to the table and sit with the microphone.
You don't have to, I don't have to come up there for you to hear me. You can hear me perfectly fine.
I can hear you, but we are creating a court record, which is audio recording.
Jurisdiction by doing what you said because you don't have jurisdiction over me. And so
Schuster,
I reserve all rights.
I did put Mr. Parent as standby counsel. Right now, you don't represent yourself. You have standby counsel.
Appoint counsel to me
Well,
without my permission. He has no permission to be my counsel. I'm here sui juris, appropriate persona. I, Jonathan Troy Colin Schuster, am here under fraud, menace, and duress. I've made a special appearance to this court for those reasons.
A new hearing, same behavior. The judge asks the defendant to approach the table to create a proper record, and he flatly refuses. This clip highlights how basic courtroom procedure becomes a battleground. The court isn't arguing ideology anymore. It's simply trying to function while the defendant resists every instruction.
I've challenged the jurisdiction of this court, and you have not answered that challenge, Ms. Jennifer. And so I have some questions for you.
well, right
Are you
now,
able to answer them?
I am not here to be interrogated by you. You are
Well,
under
I
the
just don't
jurisdiction
understand
of this.
what's going on here.
I think you understand and you choose not to
I do
take
not
in the information.
understand
Okay, well,
what's going
Mr.
on here.
Schuster,
I don't understand the nature and cause of what's going on. I don't understand how you can practice law from the bench. I don't understand how you can appoint counsel when I've told you over and over and over again that I'm here sui juris in propria persona. I'm here of a person. He does not have my permission to represent me in any way.
well, it doesn't sound like you know how to represent yourself either, which you would,
represent myself.
well, you would. Either you have counsel or you are acting pro
Represent
se.
myself. And so, like I have told you, I'm here sui juris in propria persona. I have challenged the jurisdiction of this court. You have not answered that challenge. We cannot move any further until you've answered that challenge. Is this common law jurisdiction or is this an admiralty maritime jurisdiction?
So,
Right.
Mr. Schuster, this is Carmen McDonald. I'm the prosecutor on this particular case. I think where we're at right now is you're being charged with an offense. I can barely hear you, which means the record that you're trying to make is not being picked up and not being recorded. So everything you're saying is not being preserved unless you go to the table up there near the microphone. So that's number one.
For the record, I reserve
If you
all
would
my
like-
rights. If you can step up so you can hear me better, and I will
None of
speak
it's being
louder. I will
preserved.
speak louder so you can hear me, but I reserve all my rights. And I'm speaking much louder than anybody else prior to me has spoken.
Mr.
So I just
Schuster,
want to make sure that
Mr.
the reporter
Schuster,
can hear
you
me.
are making legal arguments. All right? You are making legal arguments. They should be preserved for the record, which means it needs to be picked up and recorded.
I will
so-
begin again so that the recorder can
Not
hear me.
choosing to be silent, you're choosing to make a legal argument. So we need to have that on the record.
Here we get an extended sovereign citizen monologue. The defendant floods the room with pseudo-legal jargon, hoping volume replaces validity. The judge and prosecutor calmly redirect, emphasizing criminal jurisdiction and the need for an official record. This moment exposes the strategy. Overwhelm the court and avoid real legal accountability.
For the record, I reserve all rights.
You've made that.
I, Jonathan, Troy, Faifo, Leaso, Maliatoa, Colin, Schuster, have made a special appearance under fraud, menace, and duress. Fiduciary, Jennifer. I've challenged the jurisdiction of this court, which has not been answered. This is a Social Security Sestake trust action, which you are now a real party in interest to. This is a military admiralty jurisdiction under maritime law. However, you must realize that you have no such jurisdiction without also having a valid international contract in dispute. I am not aware of having entered in any international contracts, so I deny that any such contracts exist. Will you please instruct the prosecuting attorney to inform the court if there is such a contract? And if so, place it into evidence and explain how I'm party to it and then compelled to perform under it.
This clip is important because reality finally pushes back. The prosecutor explains jurisdiction in plain terms, tying it to everyday actions like driving on public roads. The judge listens carefully, assessing whether the defendant truly doesn't understand or simply refuses to. The contrast between clarity and denial couldn't be sharper.
1077 in this case.
I understand that the city's bringing up whether or not you're able to proceed in this matter. So whether or not you're able to understand the nature of the proceedings and be able to assist your attorney or to represent yourself, you have to be able to meet that threshold. And the fact that I think it's not that you don't understand, I think it's you choose not to understand and that you have someone giving you or spewing in court. So you're simply off base, but I don't know that it's due to a mental defect
We cannot
that is
move
causing you
forward
to not be able to
to challenge my competency because I have challenged the jurisdiction of this court,
We're
and you have not proved
not dealing
jurisdiction.
in Social Security or contract. So that's just not how it works in this court, and
No,
I don't think
that's
you
how
have
it
the
works.
legal.
You must prove jurisdiction because I have challenged the jurisdiction. If you cannot prove jurisdiction, that I move to dismiss this matter with prejudice.
That's denied.
And so, Jennifer, Miss Jennifer, can you
I'm
prove
Judge Grant, so I'm going to
Jennifer,
have you.
can you establish the jurisdiction? Can you prove jurisdiction?
Ms. McDonald, him not understanding.
I do not understand the nature or cause.
Well, he doesn't have legal training. So that I think is.
That does not matter.
Well,
If I'm here sui juris and propria persona, I'm of my own right. I'm in my proper person. You've created a bond on this matter. You've attached my social security to this matter. You're trying to charge my trust without my permission, which is illegal. It's fraud.
The judge directly challenges the defendant's refusal to engage with the law. Instead of adapting, he doubles down, accusing the court of fraud and misconduct. This is a turning point where the judge clearly recognizes the behavior as willful obstruction, not confusion, and begins steering the case firmly toward trial.
Mr. You've been charged with driving while your license was suspended in the 3rd degree and for operating a vehicle without the required ignition interlock device and refusing to comply with a law enforcement officer. You are on a deferred prosecution in another court, and the consequences are extreme for you. You are subject to another court, and they could very well.
Get in trouble, and you have to prove jurisdiction. You haven't done that.
Do you believe that courts do have jurisdiction over you?
Obviously, you have to be able to prove it, and you haven't. And you can keep pushing it and doing this, but it's just a waste of time for everybody. I definitely understand that this is not what you think it is. And whatever you need to do to prove jurisdiction, but I know you can. So if you want to waste more of everybody's time, go ahead, because obviously I'm not going to allow you to threaten me anymore, which you've done.
Nobody's threatening you.
Yes, you're telling me if I don't appear, that you're going to put me into captivity.
It's not a threat. It's a fact of life.
And that's ridiculous for what's going on here. That's absolutely ridiculous. This matter needs to be dismissed with prejudice, and whether we need to take this to trial or whatever y'all need to do to prove jurisdiction, I mean, go ahead, but obviously you can't prove jurisdiction. So
I'm looking for the more detailed counsel waiver.
It's absolutely ridiculous.
I don't know that he's done that yet.
No, he hasn't. I have a streamlined version, but I want him.
Now the stakes are spelled out. The judge lists the charges and potential consequences, including jail time. This is the court laying everything on the table. The defendant responds by dismissing it all as illegitimate, showing just how disconnected he is from the reality of what's coming if this continues.
No, you're not.
Why am I not free to leave?
Because we are still addressing your matter.
This matter needs to be dismissed.
Yeah, it's not going to be dismissed right now. So right now it's getting set for
You can't
trial.
move any further until you prove jurisdiction.
And the readiness hearing will be July 31st, and that will be at 2 p.m. And that hearing, Mr. Schuster, is on Zoom.
Any jurisdiction over me whatsoever. I've not pleaded. I've not given you personal jurisdiction.
Yes.
And you practice law on the bench.
So, Mr. Schuster, if you choose not to come to your court hearings, a warrant will issue for your
And
arrest.
you're threatening me again, telling me
Yes,
if I don't
you will be
play your
expected
game,
to appear.
and you just said yes. Oh my goodness. That if I don't play your game, you will put me in captivity. This is ridiculous. Absolutely ridiculous.
Yep, these are jailable offenses, but for this
Absolutely
hearing,
ridiculous,
we need
Jennifer.
your presence to appear.
Absolutely ridiculous.
All right, let's get a court date form for him.
Absolutely ridiculous.
All right, guys, this is the climax. The defendant thinks he's free to walk out, and the judge immediately shuts that down. Authority is reasserted, court dates are set, and arrest warnings are made crystal clear. This moment perfectly captures the consequences of refusing reality. If you found this breakdown useful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.